So how does this DCPD work? Well, if you are involved in a collision where you are the not at fault driver, then you look to your own auto insurer to cover the cost to repair your vehicle. The DCPD does not change auto insurance, it only changes who pays for your property damages. The DCPD has been introduced to align better with insurance premiums associated with the actual cost to repair your vehicle. So what happens to subrogation? With DCPD, the right to subrogate is virtually eliminated. The thinking behind this is that there will be less administration, the DCPD will be more efficient and timely, and probably most importantly, the DCPD was more customer focused. So you will be dealing with the insurance company that you chose to cover your auto insurance to deal with your not at fault property damages.
So fair practices regulation, it has a hodgepodge of things, the principal object of which is to protect insureds from being the victims of their ignorance of the law, right? For lack of any other way to put it, right? I think that the driving force was that courts could see that insurers that are walking into these things, very sophisticated. They know about limitation periods. They know all kinds of things about the law that the insured doesn't know. And the insureds are just wandering along in the dark until ping, time's up. Sorry, you haven't sued me. File's closed. So that is one of the things, and this was the point in the fair practices regulation that was at issue in this Statt and SGI case, which is the requirement to give notice to the insured of the limitation period. So that requirement, the important point of it is that it carries with it a potential penalty, which is that an insurer that fails to provide adequate notice of the limitation period to the insured may find that that limitation period is no longer enforceable against the insured, because the insured can ask the court to waive or extend the limitation period if proper notice wasn't given.
We're all aware of Bill 41, and part of the Bill 41 changes made some changes to how plaintiffs can collect prejudgment interest. These are promulgated under Section 582 of the PGI Act. I won't read that out for you, but I will sort of take the three takeaways from that section. So firstly, Section 582 make sure that these changes only apply to motor vehicle accidents. So it won't apply to things like occupiers, claims, etc. Number two, the plaintiff does not get PGI until either the earlier of when they first provide notice to the insurer or they file their statement of claim. And lastly, there was a change where the non-pecuniary damage rate is no longer for 4%, but is now under the floating rate for pecuniary damages under the judgment interest regulations. And that amount varies from year to year. I think a couple of years ago, it was somewhere around 1.5% interest. Last year, it was a whopping 0.2% interest. And that's a fair change to insurers from the 4% you get under the Judgment Interest Act itself. So the date the changes came into effect was December 9th, 2020. And one question we often get asked is, so does these apply to claims or accidents that happened before December 9th, 2020?